All right, hi, welcome back, Attorney Steve Vondran. Today we're going to take a quick look. I'm on my blog here at vondranlegal.com. I've just posted a blog and I thought, maybe I should just do a video on this because it's a really interesting, timely topic with this AI technology that is exploding on the scene. And the really question here is a very simple question. Can you copyright the creative outputs of machines like Wonder and DALL-E and ChatGPT? Can you copyright it? Can you make a book based on ChatGPT and copyright it, or an image using the Wonder tool or DALL-E? Can you copyright this stuff? So here's a case, Thaler versus Perlmutter from the United States District Court for the District of Columbia, and Judge Beryl Howell said, no, you can't create. Here's the picture at issue. The plaintiff came up with a program where basically was using a program, and I think he developed his own computer programs, as he describes as having artificial intelligence capable of generating original pieces of visual art akin to the output of human artists. So it's basically a machine learning type of tool that has created this piece of art, this photograph or illustration. And, it's kind of interesting. It's a little, looks like a little train track going through a tunnel. So it's kind of cool looking. This was the image at issue. He wanted to get it copyrighted. The United States Copyright Office turned him down. You can read the background facts here. Said, no, you can't do that. It's not a human. Only humans can register for copyrights, okay? Here's some key phrases I highlighted in bold for you to make it nice and simple. Historically, the understanding that authorship in copyright law, original works of authorship are copyrightable. Original works of authorship fixed in a tangible medium of expression. The understanding that authorship, that part, is synonymous with human creation, not a machine, not a computer, has persisted as the copyright law has evolved. Okay, so there's a little history here if you want to go through it. I'm only going to hit the bullet points. The human authorship requirement has also been consistently recognized by the Supreme Court when called upon to interpret the copyright law. As already noted in the Sereny case, the court's recognition of the copyrightability of a photograph rested on the fact that the human creator, not the camera, conceived of and designed the image and then used the camera simply to capture the image. So these were some of the arguments the plaintiff was making. Hey, I have the thing, I own the computer, I own the machine, I told it what to do. So the output is really what I told it to do, and the court was not going for it. Further on, in Mazer versus Stein, the court delineated a prerequisite for copyrightability to be that a work must be original. That is, the author's tangible expression of his idea. In Goldstein versus California, author and originator is defined as he to whom anything owes its origin. In all these cases, authorship centers on acts of human creativity. Okay, so there needs to be that human element. Going down further, in the Ninth Circuit, we have a case here. The Urantia Found versus Kristen Mahara case. This was a case where somebody claimed to embody the words of celestial beings rather than human beings. And somebody basically said that it was divine intervention that helped them create this thing, and so it was copyrightable. And the court said it is not creations of divine beings that the copyright laws were intended to protect. Finding that because of the members of the contact commission chose and formulated the specific questions asked of the celestial beings, and then selected and arranged the resulting revelations, the Urantia book was at least partially the product of human creativity and thus protected by copyright law. So there you can see in the Ninth Circuit talking about, if you have some, even if it's a divine creation, some inspiring words were told to you and you wrote a book, even though you weren't technically the author, some divine being was the author, you can still get a copyright if there is some product, if it's the product of human creativity, okay, some human input. In Penguin Books, they found a valid copyright where a woman had filled nearly 30 stenographic notebooks with words she believed were dictated to her by a voice, which would speak to her whenever she was prepared to listen, and who had worked with 2 human co-collaborators to revise and edit these notes into a book, a process which involved enough creativity to support human authorship, okay? So hopefully you're getting a sense of what the courts are looking for, some human involvement here. In Kelly versus Chicago Park District, 7th Circuit case refused to recognize copyright in a cultivated garden, as doing so would press too hard on the basic principle that authors of copyrighted works must be human, okay? The garden owed its form to the forces of nature. Even if a human had originated the plan for the initial arrangement of the plants, and as such lay outside the bounds of copyright. Finally, in Naruto versus Slater, that 9th Circuit once again held that this was the case of the monkey that took a photo of himself, and they tried to register the photo, and the court said, no, well, the monkey is not a human. A monkey, if it was a human taking the photo, yeah, that would be copyrighted, but a monkey taking his photo, that doesn't copy. So here it says, the alleged infringement of photographs this monkey had taken on himself for all animals, since they are not human, lacked statutory standing under the act. So even if you had it, only humans had standing to file a lawsuit. So plaintiff can point to no case in which a court has recognized copyright in a work originating with a non-human. So if you get your dog to take their picture, or you have some kind of pet that's able to take their own picture, that's not going to qualify according to this case. And this is an interesting section. Undoubtedly, we are approaching new frontiers in copyright as artists put AI in their toolbox to be used in the generation of new visual and other artistic works. The increased attenuation of human creativity from the actual generation of the final work will prompt challenging questions regarding how much human input is necessary to qualify the user of an AI system as an author of a generated work, the scope of the protection obtained over the resultant image, how to assess the originality of AI-generated works, where the systems may have been trained on unknown pre-existing works. Some of these AI tools are trained on existing copyrighted works, and that is getting them sued. There are some lawsuits being filed against these programmers that created these tools, saying, how did you teach your machine how to learn these copyrighted images? Sure looks like mine on there. Looks like you were using my image to train your AI, and that's being used in final outputs for other parties. So anyway, this is going to be a cutting edge issue. It's going to keep growing. As you can see here, when he applied for copyright, he asserted that he provided instructions and directed his AI to create the work, that the AI is entirely controllable by him, and that the AI only operates as his direction. Court wasn't buying it. There was also an argument about work for hire. He tried to say, well, this was a work for hire. I hired the machine to do the work. And so that was shot down in a footnote in the holding here. In any event, plaintiffs attempt to cast the work as a work for hire. Click here if you want to know more about work for hire. It's a very important topic for artists and creators. Must fail, as both definitions of a work made for hire under the Copyright Act require that the individual who prepares the work is also a human being. No work for hire in a machine. So nice try. Court shot it down. And there you have it. So make sure you subscribe. As you can see, we have 783 videos. Lots of great stuff here. You can flip through and see my different videos on various topics and just enjoy. But anyway, this is general legal information only, not legal advice. And if you need help with AI copyright issues, you know where to find us. Here it is right up here, VonDranLegal.com. That's VonDranLegal.com. Thank you guys for listening. Feel free to share this video on your social media networks. Have a great weekend. Gotta run. Bye.